In Court of India, Civil Appellate Jurisdiction, Civil Appeal number 14132 of 2024, State of Odisha and others versus Dilip Kumar Mahapatra. Judgment आसी जाइछि मनोज मिश्र जज रे लीव ग्रांटेड बाय एन ऑफिस ऑर्डर डेटेड 23/4/2001 issued by the Director of Teacher Education in SCRT Bhubaneswar, Odisha. The first respondent was engaged as computer technician at the College of Teacher Education Baleshwar. The term of his engagement were as follows. SCRT direction ने जने computer teacher engage होइतले. Is engaged as computer technician at College of Teacher Education Baleshwar in the scale of 5,500 to 9,000 with usual DA and ADA as admissible from time to time for a period of 1 year or till the post is filled up on a regular basis, whichever is earlier, with effect from the date of joins in the assignment. This is purely temporary assignment to help operate the computer system available to the college under UGC development grant. जन कंप्यूटर टीचर को पोस्टिंग कर 5,500 रु 9,000 डीए एडीए सहित जहाँकि कंडीशन थिला ये पोस्ट टेम्परारी एवं गोटे वर्ष किंबा रेगुलर मोड रे पोस्ट फिलअप हवा पर्यंत जोटा अर्लियर हेबा सेतिक पर्यंत यार अवधि थिला. Pursuant to the order of engagement, the first respondent joined in the office of the principal of the college on 1/5/2001 posting पाइले. Later his services were dispensed with by the director head officer dated 22/1/2002, which reads thus: as the service of this Dilip Kumar Mahapatra working as computer technician in the city Baleshwar no more required is hereby terminated with effect from 22/1/2002 afternoon. तेणु टर्मिनेशन कर दिगला 2002 रे. Agreed by the disengagement order, the first respondent filed OA number जोटा 2002 before Odisha Administrative Tribunal Katak Batch inter alia the following grounds. The order violates the principle of natural justice and the order is bereft of reasons. OA रे करिथिले केस. The appellant जे कि स्टेट ऑफ ओडिशा contested the proceeding before the tribunal inter alia on the following ground रे contest करिथिले गवर्नमेंट ऑफ ओडिशा. The engagement of the first respondent was purely temporary and for a fixed term just to meet the exigency of establishment, training program and pre-service training program, and since December 2002 the pressure of work had lessened. The first respondent was disengaged. जेहेतु यह एक टेम्पररी पोस्ट थिला एवं से डेट रु प्रेशर ऑफ वर्क मध्य लेस हो जाइथिला सेथिपय ताको डिसएंगेज करा जाइथिला. द एंगेजमेंट वाज नॉट पर्सुएंट टू एनी recruitment exercise, therefore the first respondent had no right to the post. जेहेतु रिक्रुटमेंट प्रोसेस नथला तेणु तांको राइट नाही बोली सरकार दर्शाइथिले. During the course of proceedings before the tribunal, the first respondent placed reliance on two orders passed by the tribunal. Tribunal द्वारा पास होता दुईटी ऑर्डर उपर रिलायंस करथिले candidate, wherein according to the first respondent similarly situated person like the first respondent were given the benefit of reinstatement and pursuant thereto they were afforded regular appointment. एमिति सिमिलर केस रे मध्य व्यक्ति को रीइंस्टेट कराइथिला रीएंगेजमेंट कराइथिला एवं पर पर रेगुलर अपॉइंटमेंट रो सुविधा दिया जाइथिला. The tribunal took the view that since the first respondent was not appointed by following any procedure known to law for appointment to a public post and the engagement was for a fixed term, the only relief which could be granted to him is pay and allowance from the date of his disengagement till expiry of his original term of engagement 30/4/2002. तो ओएटी कहिथिले 22/1/2002 रु 30/4/2002 पर्यंत ताको दरमा मिलवा दरकार. Agreed by the order of the tribunal, the first respondent invoked jurisdiction of the Odisha High Court at Katak under Article 226, 227 Constitution of India. By the impugned judgment and order dated 15/2022, the High Court allowed the writ petition, quashed the order of the tribunal, and directed reinstatement of the first respondent in service with all service and financial benefit as due and admissible to the post while directing so the High Court reasoned thus. आउ ट्रिब्यूनल जेहेतु कैंडिडेट कथा को रखी नथिले री एंगेजमेंट री इनस्टेट देई नथिले केवल कही जे दरमा पाइपर 30/4/2002 पर्यंत किंतु हाईकोर्ट रे से अपील पुणी करते हाईकोर्ट कहते रिइनस्टेट करने। This court, after going through the materials available on record, finds that petitioner was appointed as a computer technician at Video Order number 23/2001 under Annex 1. The said order was issued with a condition that petitioner will continue for a period of 1 year and or till the post is filled up on a regular basis. But prior to the completion of the said period of 1 year and prior to taking any step to fill up the post on the regular basis, the petitioner was abruptly terminated from this service by order under Annex 3. From the pleadings available on the record, it is quite evident that prior to issuing such order of the termination under Annex 3 on 22/2002, the petitioner was neither so called or nor any opportunity of hearing was given to him. The impugned order of termination was also passed without assigning any reason whatsoever. It is also not the case of the opposite party that the petitioner prior to being terminated was ever so called and given an opportunity of hearing. कौन सुजोग दिया सो कज कि हियरिंग्स करने एवं जो कंडीशन था गोटे वर्ष पूर्ण कि रेगुलर पोस्टिंग तार मध्य प्रोसेसिंग आरंभ होना तेणु दिस कोर्ट finds that persons similarly situated and disengaged along with the petitioner were re-engaged and subsequently regularized in their service in terms of the order passed by Tribunal OA number 2242/2002. ତେଣୁ ତାଙ୍କୁ ପୋଷ୍ଟିଂ ମିଳିବା ଦରକାର ଏବଂ ରେଗୁଲାର ମଧ୍ୟ କରିବା ଦରକାର। Since the Tribunal while entertaining similar application allowed the claim of the interfering with the order of termination and pursuant to the order so passed, the applicants in OA number 481/2008 and OA number 2242/2002 were not only re-engaged in their services but also have been regularized in the meantime as per the considered view of this court. The petitioner is entitled to get similar benefit. The tribunal, as per the considered view of this court, never take into account of the benefits extended in favor of the applicant. जेहेतु देखंतु यही सिचुएशन ने हाईकोर्ट करथिले एमिति ऑर्डर तो निश्चित भाव देखंतु यह को चैलेंज मध्य करा जायतिला सुप्रीम कोर्ट को कथा पहुँची देखिपारे analysis करथिले सुप्रीम कोर्ट. We have considered the rival submission and have pursued the materials on record at the outset. We may observe that there is no dispute as regards the engagement of the first respondent being purely temporary to help in the operation of computer system made available to college under UGC development grant, and that too for a fixed term of 1 year till a regular selection is made, whichever was earlier. Further, there is no material to demonstrate that the first respondent was engaged or appointed against a pre-existing or a freshly created substantive vacancy, and that his engagement appointment was made by following a procedure prescribed by a statutory rule or executive instruction. सुप्रीम कोर्ट कहते जे जहाँ रेकर्ड रही कौन सी प्री एक्जिस्टिंग पोस्ट एगेन्स्ट रे फिलअप होली नथिला एवेलेबल नथिला किंबा तार कौन सी प्रोसीड्योर एवेलेबल नहीं. In Secretary State of Karnataka and others versus Uma Devi, this court had cautioned constitutional courts against issuance of direction for regularization, absorption or continuance of temporary, contractual, casual, daily wage or ad hoc employees unless the recruitment itself was made regularly and in terms of the constitutional scheme. अलगा केस कर्नाटक केस कही सुप्रीम कोर्ट जदि रिक्रुटमेंट रेगुलारली है नथिबो एवं कॉन्स्टिट्यूशनल स्कीम रे है नथिबो किंबा से गुडी को रेगुलर करिबा ऑब्जर्वेशन करिया पई ताहा को दिया न जवा उचित. Importantly, in this case, the tribunal had returned a finding that there was nothing on record to demonstrate that appointment was made by following any known procedure. Admittedly, the engagement of the first respondent was for providing help in running computer system made available UGC development grant under. Further stand of the appellant before the tribunal was that for a shortage of work available, such persons were disengaged. In these circumstances, even if it is assumed that in absence of any allegation of misconduct, they ought not to have been disengaged prior to completion of their term, direction to reinstate, re-engage them, particularly after the term period was over, was not justified in our view. Therefore, the tribunal was justified in only granting compensation to the first respondent for the remaining period of his term. ତେଣୁ ଟ୍ରିବ୍ୟୁନାଲ କହିଥିଲେ କେବଳ ତାଙ୍କୁ କମ୍ପେନସେଟ୍ ଯେଉଁଟା ଟର୍ମର ଆଉ ବାକିଆ ସମୟକୁ ଦରମା ଦେବା ପାଇଁ କୁହାଯାଇଥିଲା। ହାଇକୋର୍ଟ ହାଏଭର ଗ୍ରାଣ୍ଟେଡ୍ ରିଲିଫ୍ ଦେଇଥିଲେ ରିଏନଷ୍ଟେଟମେଣ୍ଟ କରିବା ପାଇଁ, କାହିଁକି ନା ସିମିଲାରଲି ଡିସଏନଗେଜ୍ ପର୍ସନ୍ ଟ୍ରିବ୍ୟୁନାଲଙ୍କ ଦ୍ୱାରା ଦିଆଯାଇଥିଲା ରିଏନଗେଜମେଣ୍ଟ କରିବା ପାଇଁ। This is in your view was not legally correct because High Court ought to have examined Tribunal's order qua first respondent on its own merit, particularly when the High Court was not bound by Tribunal's order. Besides that, the state cannot be forced to suffer an order which is not in sound in law. ତେଣୁ ହାଇକୋର୍ଟଙ୍କୁ ମଧ୍ୟ ଦର୍ଶାଇଛନ୍ତି ସୁପ୍ରିମକୋର୍ଟ ଯେ ଯେତେବେଳେ କେଉଁଟା ଲ ଅନୁସାରେ ହେଇନଥିବ ତାହାକୁ ବାଧ୍ୟ କରିବା ଉଚିତ ନୁହେଁ। ଷ୍ଟେଟ୍ ଅଫ୍ ଓଡ଼ିଶା ଆଣ୍ଡ ଅନୁପ କୁମାର ସେନାପତିରେ ଆଫ୍ଟର ନୋଟିସିଂ ଏ ସିରିଜ୍ ଅଫ୍ ଡିସିସନ୍ a 3-judge bench of this court rejected an argument that petitioner must get the benefit of parity even if they are not otherwise entitled to the relief. ଏହି କେସ୍ରେ ସୁପ୍ରିମକୋର୍ଟର 3 ଜଣିଆ ଜଜମେଣ୍ଟ ମଧ୍ୟ ଦିଆଯାଇଥିଲା। In our opinion, there is no concept of negative equality under Article 14 of Constitution. In case the person has a right, he has to be treated equally, but where right is not available, a person cannot claim rights to be treated equally as the right does not exist. Negative equality when the right does not exist cannot be claimed. In state of UP and versus Rajkumar Sharma, others thila, the court held that even if in some cases appointment have been made by mistake or wrongly, that does not confer any right on another person. It was also held that Article 14 of the Constitution does not envisages negative equality को गुरुत्व दियाଯିବ ନାହିଁ ବୋଲି କହିଥିଲେ। ଏଇ ଦେଖିପାରୁଥିବେ ଏଇ ଡିସ୍କସନ୍ को आधार करी we are view of that direction of the High Court to reinstate or re-engage the first respondent, particularly after lapse of the term of his engagement, is not legally sustainable. ତେଣୁ ସେ କହିଥିଲେ ଯେ re-engage କରିବା ଆଇନ ଅନୁସାରେ ସିଦ୍ଧ ନୁହଁ। The question which now arises is so that what relief the first respondent to be provided at this stage. Admittedly, the direction of the High Court to reinstate or re-engage was not implemented on account of stay on contempt proceeding. Therefore, equities have not been created in favor of the first respondent by the dint of length of his continuation in service. In such circumstances, the first respondent can be compensated with monetary compensation. ତାଙ୍କୁ monetary compensation ଦିଆଯାଇପାରେ। In ordinary circumstances, the relief of the compensation as was awarded by the tribunal would have been sufficient. ତେଣୁ ଟ୍ରିବ୍ୟୁନାଲଙ୍କ ଅର୍ଡ଼ରଟା ହିଁ ସଫିସିଏଣ୍ଟ ଥିଲା। But here the state is held to have treated similarly situated person differently, which has resulted in unwarranted expectation and prolonged litigation. No doubt, an attempt is there on part of the state to distinguish the case of the first respondent with those in whose favor tribunal's order was there, but details of those distinguishing features have not been brought to our notice. କୁହାଯାଇଛି under these circumstances, we deem it appropriate to award a lump sum compensation of rupees 5 lakh. ତେଣୁ ତାଙ୍କୁ 5 ଲକ୍ଷ lump sum compensation ଦିଆଯାଉ। Accordingly, the appeal is allowed. Order of the High Court is set aside. The appellant shall within 3 months from today pay rupees 5 lakh to the first respondent. The said amount shall be full and final settlement of all claims of the first respondent qua applicant pending application if any stand disposed of. तो निश्चित भाव देखो ये पूरा 14 पेज डिटेल्स एनालिसिस कर देइछन्ते ऑर्डरटी को। एथरो गोटिए कथा स्पष्ट होउची जो माने प्री एक्जिस्टिंग वैकेंसी एगेंस्ट पोस्टिंग हेई नथिबे कॉन्ट्रैक्चुअल से मानकर री एनगेजमेंट बेआईन एवं ତାହାକୁ ମଧ୍ୟ ସୁପ୍ରିମକୋର୍ଟ କାଟିଛନ୍ତି। ଏହା ଓଡ଼ିଶାର କେସ୍। ଯଦି ଆପଣଙ୍କର ପ୍ରି ଏକ୍ଜିଷ୍ଟିଂ ଭ୍ୟାକେନ୍ସି ସେକେଣ୍ଡାରୀ ହେଇଥିବ ଏବଂ ରେଗୁଲାର ରିକ୍ରୁଟମେଣ୍ଟ ପ୍ରୋସିଡିଓର ହେଇଥିବ ତେବେ ଆପଣଙ୍କୁ ସବୁ ସୁବିଧା ମିଳିପାରିବ ବୋଲି ଏଥିରୁ ସ୍ପଷ୍ଟ ହେଉଛି। ଏବଂ ଯେହେତୁ ଜଣେ ଏତେ ଦିନ ଧରି ଲଢ଼େଇ କରିଛି ତାଙ୍କୁ 5 ଲକ୍ଷ ଟଙ୍କାର କମ୍ପାନସେସନ୍ ଦେବା ପାଇଁ ମଧ୍ୟ ସୁପ୍ରିମକୋର୍ଟ ସରକାରଙ୍କୁ ବାଧ୍ୟ କରିଛନ୍ତି। ଭଲ ଜଜମେଣ୍ଟଟି ଆସିଛି। ତ ଏଥିରେ ମଧ୍ୟ ଶିକ୍ଷକମାନଙ୍କର କେସ୍କୁ ତୁଳନା କରାଯାଇପାରେ। ଦେଖିବା ପରବର୍ତ୍ତୀ ଅପଡ଼େଟ୍।